Very good afternoon, ladies and gentlemen. My topic actually is, firstly, it's difficult because it's at this time of the day and people are now concerned about the traffic heading back. So I won't keep you seated for that long. I will open up to questions. This morning, Anand spoke. I swear to you, I didn't give him a free copy of my book, so I don't know where he got that information from. But he's actually always on the other side with me. I think if you look at my paper and his paper, we didn't exchange either. There's a common topic or common passage, which is the definition of misconduct, right? And this year and last year saw two federal major decisions by the federal court in respect of the punishment, right? You know, in industrial jurisprudence, I always say this, you just have to remember three things. PMR, right? If your kids are studying for exams, just remember PMR. When somebody asks you how to dismiss an employee with cause, performance, misconduct, and redundancy. Of course, each has its own little procedures and steps that you have to follow in order to establish just cause at the industrial court. But my paper is basically how do you manage a minor and major misconduct. Now, do you know what the definition of a misconduct is? I asked someone what is a misconduct and he told me salah laku. I said yes. But what is a misconduct? Anybody? We go back to the basic definition in Okay, this is the case, right? It says any conduct on the part of an employee inconsistent with the faithful discharge of his duties towards his employer would be a misconduct. Any breach of the express or implied duties of an employee towards his employer, therefore, unless it be of a trifling nature, would constitute an act of misconduct. In industrial law, the word misconduct has acquired a specified connotation. It cannot mean inefficiency or slackness. Just remember, it's not inefficiency or slackness. That is more performance related, all right? Because I have a lot of clients, they deal with a poor performer and they subject him to a domestic inquiry. And I think it's an absolute waste of time because performance is very subjective. So the law says there must be a paper trail highlighting the employee's shortcomings, giving him sufficient opportunity to improve before you dismiss. So you need not convene a domestic inquiry when it comes to performance. Because at the end of the day, as I said, it's very subjective and the courts will require the paper trail and the evidence to show that he was a poor performer, he or she had been given sufficient opportunity to improve and did not improve, hence a termination. Right? So for misconduct, yes. But when do you do a domestic inquiry? I'll come to that shortly. Right? So they say the charge of misconduct, therefore, is the charge of some positive act, I beg your pardon for the typographical error there, act or conduct which would be quite incompatible with the express and implied terms of the relationship of the employer and employee. Now, an express term is in your contract of employment, very clear. When you engage someone, that's the starting point. The contract of employment is very, very important because it basically sets the guidelines of your relationship, right? Now, like a marriage, right? But at the end of the day, none of us, I don't think any one of us have got these prenuptial agreements. I don't have. I don't know. Anyone here who's got a prenuptial agreement? No, right? So, but in a contract of employment, you must state it clearly. So things like retirement age, transfer clause, these are very important components. Of course, now you've got the Minimum Retirement Age Act, but that is just the minimum retirement. It doesn't mean retirement. So the law stipulates a person will retire at the age of 60, that's the minimum. He can actually work till 70 if your contract of employment, if you want to employ a guy exceeding that retirement age, that's fine, right? So, for misconduct, you must establish the misconduct. Now, the biggest hurdle I think we have now, my paper again goes back to how do you manage, right, a minor or major misconduct. The biggest hurdle I think for most, can I go on the presumption that majority of you here are HR practitioners, not the employee, not the owner, the boss. Now your biggest hurdle is to actually manage your boss. It's not managing a major and minor misconduct. It's not an issue, but a lot of employers, the owners of the business, they really have no time when you go and tell them, listen, we must have a paper trail, we must conduct this, because as far as they're concerned, they're not interested. I'll give you an example. Say you have a printing press. Give you an example, say the Malay Mill those days when it was in Jalan Riung, right? As far as the production manager is concerned, at 10 a.m., 100,000 copies of the Malay Mill should be ready to be for sale, right? Printed and ready for sale. That's his KPI. Now, from a HR perspective, the HR, where is the HR manager based? He's not sitting in the morning shift when the workers come in at 5 o'clock in the morning. So when a worker comes in at 5 o'clock in the morning, he's supposed to clock in at 5. He clocks in at 5:30. What happens? Right? The superior scolds him, right, and says, get on to work. But by 10 o'clock, he has forgotten about that guy coming to work late because he has achieved his KPI, 100,000 newspapers out. But when your human resource manager goes to see the superior, 6 months later when he's due for confirmation and says, listen, Mr. X is due for confirmation, what are your views? He says, sack the guy. Why? He always comes to work late. Then you say, have you documented his late coming? No. So how do you sustain a case like that? Because at the end of the day, the evidence is late coming. And the defense used by most employees is condonation. If you don't take any action immediately, then you have actually condoned the misconduct. Now, I don't know whether you read the newspapers. Recently, I did a case for a bank where sexual harassment, where the employee was a manager and he had given a book to his subordinate titled 100 Kehebatan Lelaki, right? And I think was it? Yeah, I can't remember. Was it? Yeah, that's right. 100 Kehebatan Lelaki. And he also used to text her saying, I L you. So I asked him, what do you mean by I L you? He says, I love you, right? And I said, so why do you send it to your staff? Oh, that is to motivate her. When they hit their target, I'm so happy, so I SMS them saying, I L you, right? And then I said, why do you give her the book? He says, oh, that book was not banned by the Kementerian Dalam Negeri. It can be bought in the Pasar Malam, right? But I said, you're a superior, would you, the test, just remember this, the litmus test is, would you give or would you behave in such a manner towards your loved one by sending these kind of messages? Would you send it to your daughter, to your wife, to your cousin? No, right? So same thing, when you talk about sexual harassment at the workplace, I always ask this question, would you have sent such a message to a loved one? So I asked him, would it be permissible if someone sent that to your loved one? Right? He said, tak boleh. So what happened was, the industrial court said, because the lady delayed in complaining, there was no sexual harassment and reinstated him 4 years later. We went to the High Court, we overturned the decision on the basis it was perverse, right? And the Court of Appeal overturned the decision of the High Court on the basis that the complainant took too long to complain. But the complainant did say in evidence that she was fearful because it's her boss. So, at the end of the day, you can fight a case, but if you don't manage the misconduct properly, how do you manage a misconduct? I think the keynote is to ensure, the key emphasis is to ensure you have a proper, your terms and conditions of employment, your manual, properly addresses the kind of misconducts that attract a certain level of punishment. But some companies, they put their major misconduct and minor misconduct. But if there is a repeat of the minor misconduct, what happens? I've got cases where the guy says, well, my misconduct is categorized as minor, so you can't sack me. I can do it 10 times. It's minor. And there are some misconducts, if you look at some of the handbooks, only lately people have developed this sexual harassment and all that, but there's some misconducts which are not even stated. So the guy says sexual harassment is not in the list, so I'm okay. Because it's not in major, not in minor. So how do you manage that? So I think the most important thing is you have to manage your superiors to tell them, listen, at the end of the day, we are HR, we should be given the power, the resources to ensure that all these things are well documented. You need to train. You need to train because when you talk to your production manager and say, listen, you need to have a paper trail, the guy is saying, hey, what are you trying to waste my time? I've got a KPI, I've got a target to achieve. I've got no time to sit down there and fill up forms and all that. But at the end of the day, who gets called to court? It's not the HR manager. I've got many cases now in court. The HR manager comes in, and after cross-examination, they are made to look like postmen. Because at the end of the day, they say, saya cuma maklumkan keputusan. But they say, who made the decision to terminate? So some companies, they have a disciplinary committee. So they have a DI, and then the DI, because the DI has to be independent, right? They're not supposed to know the personal records. They don't have the personnel file. So they are just there to see whether the misconduct has been established. Once the misconduct is established, then they move it to a disciplinary committee who would then have basically the employee's past records. So this committee plays a very important role, because then you can see whether this guy has some kind of track record of repeating this kind of offenses. Then you decide what kind of punishment to be meted out. Because the test at the industrial court is, first, you have to establish the misconduct. If you do not establish the misconduct, there's no case to answer. So to establish the misconduct, what do you need to do? So the first part of the establishing of the misconduct is very important, because you need to collate the evidence, right? It could be documentary. So you may have a WhatsApp. I had one instance recently where the person sent his something which was quite demeaning to his subordinate, but almost immediately then apologized, saying wrongly sent. But do you know how dangerous it is? Even I myself sometimes, when you press send, it can go to the wrong person, right? But how do you collate that information? How do you preserve that evidence? If somebody, say there's a sexual harassment complaint, the girl says, somebody sent me an S, which amounts to sexual harassment. What do? You need to collect the evidence, correct? Now, without the evidence, you have no case to answer. I did a case some time ago on sexual harassment. I asked, because this guy attended a seminar, which I did. So he called me the next day and said, listen, Tava, thank you very much. Really appreciate what you've done. I have just got a sexual harassment case. So I said, what do you do? He said, the girl came and complained. I immediately suspended the manager. I said, very good. Because if you don't suspend, what happens to the victim? The victim will say, this is not a safe place. I think Yong talked about the workplace environment. So the victim will say, this is not a safe place to work. I complained, you did nothing, right? Other than the Minister of Women's Affairs coming to your office, right? You may also be exposed to a constructive dismissal claim, because the employee says, I complained, you did nothing, I don't feel safe anymore, I'm walking out. So I said, very good. What did you do about the complaint? He looked at me and says, what is that to do? She complained. I said, yeah, did you take the particulars down? He said, oh, I haven't done that yet. I said, all right, do it tomorrow morning. Record the statement, because you need to know, when you charge someone for a misconduct, there is a case called Esso against Maimuna, where the court said that it's important, if it's quasi-criminal in nature, then you have to set out particulars of the offense, the charge. So the date, time, place, and the nature of the offense has to be stipulated in the charge sheet in order to establish the misconduct. You can't say that you committed, you sexually harassed Miss X 10 years ago or 2 years ago. There must be date, time, place, right? So I said, get down the particulars. But you know what happened in this case? The next day, when he called the girl in and said, okay, can you give me the details? She said, I don't know what you're talking about. Right? And you know what the guy did? The guy then wrote a letter to the HR guy and said, listen, as far as I'm concerned, because the guy who wrote the charge was very, very articulate in the wording of the charge, the allegation. He said that you had sexually harassed Miss So-and-so, and pending your reply, you are suspended on full pay until further notice. So he then writes a letter to the HR manager, the poor guy who's just doing his job, to say, I'm suing you for defamation. Right? I suspect the night before, the moment he got the suspension, he must have sent a rombongan, not to meminang the girl, but to threaten the girl. Right? Because her story completely changed the next day. So documentation is important. People don't realize, sometimes some employees, through no fault of theirs, when they're accused, when you're caught red-handed, they panic. I have a case also where the girl, she was pregnant, she had put her hand in the till. So the manager said, listen, I think it's better you put the money back and you go. She said, yes. Can you do me a favor? I'm really traumatized. Can you write the letter for me and I'll sign it? So she wrote the letter in her own handwriting. Right? I mean, the manager wrote the letter in her own handwriting and the girl signed. What happened after that, I have no idea, but I presume she must have gone back home and the husband would have asked her, so not going to work tomorrow? And she basically, the whole story turned, she said, I was forced out of employment. There was some issue of money missing and they blamed me and they made me sign a letter of resignation. In fact, the handwriting is even not mine. I was forced to sign. So again, a good deed could backfire. So the solution is type it out. Right? Using somebody else's computer. Don't print it, because at the end of the day, people can trace. So these are, I just want to share with you the real life situations. I had another case where the girl went to complain to the boss about the staff, her colleagues sexually harassing her. And you know what? I had really good business in that company. We had 2 cases. Because you know what the boss did? He put his arms around the girl and said, sayang, jangan risau, abang akan jaga you. So, sexual harassment 1 in the plant and sexual harassment 2 by the manager. So we had two cases at one go. Now, how do you manage this? Right? Again, it's education. You need to highlight. It's good for you to attend these kind of conferences, but it's good to use people like Mecca or MEF, whoever your consultants are, right? Get them to come or send your staff or come and conduct trainings, right? You do that, right, Daman? Yeah, training to educate your workforce as to know their rights. What are the kind of exposure that they could lead themselves and the company to as a result of being ignorant, right? So sexual harassment is one aspect. Now, late coming. You have people, in the Employment Act, this is 2 continuous days. So this guy, or even if you have 3 days or 4 days, what this guy does is every time 2 days, about to be the next day, he comes back to work. Then the following week he does that. Now, how do you? It technically falls under minor misconduct. So what do you do? The case I did with Anand was an illegal picket, right, which occurred at CIMB Bank. It went all the way to the federal court. The question that arose was whether walking into the banking hall for 2 minutes with placards saying CIMB cheats their workers, and balloons running around, one guy ran around the banking hall in the lobby, amounts to a misconduct that warrants a dismissal. Right? So our argument is, at the end of the day, whether it's a minute or 10 minutes makes no difference. The moment you cross that line, it becomes an illegal picket. You can picket outside during office hours, but the moment you step into the premises, you have breached the law. That's why you take $1 or $1 million out of the till, no difference, correct? Now, people who know me here will always, I don't want to bore you, but I just give you the 3 examples. When you handle minor, I think Daman must have asked me to come and speak on this topic because they know I love this joke. Now, if you have a bakery, right, where the buns roll out, and a Bangladeshi, anybody from Bangladesh here? Okay. As the buns roll out, the Bangladeshi worker takes 1 bun and eats it. Has he committed a misconduct? Has he committed a misconduct eating that 1 bun? Yes? Who says no? I had one guy who put up his hand and said no, because the guy was hungry, right? And it's good for the staff to taste the quality control. I said, he's not a quality control manager, right? Then they also told me, but there were no signages. The guy doesn't know. I said, assuming there are signages in Malay, Chinese, Indian, and Urdu to say you cannot eat the bun as the buns come out. Buns are meant to be sold, right? So you agree with me, he's committed a misconduct? Would you sack him for eating that one bun? Now, if you see in my paper, I'm not going to show this to you, it's in my file, the Carlsberg case, right, where the theft of one can, the court said, it is not serious enough to warrant dismissal. You have to look at the mitigating factors and, what he apologized and all that. At the end of the day, you can commit a misconduct and apologize. But the question is, whether it's sufficiently serious to warrant dismissal and whether it'll send the wrong message to the rest of your staff. So a lot of people say, oh, it's a one-off. You've got very kind employers who say, it's just a small matter. But it will send the wrong signal, right? So you got that situation. Now, if you have a similar situation in a bank, right, and say a teller at the bank, if the child comes down, her son comes to the bank and says, listen, Mom, I forgot to bring my wallet. Can you lend me $10 to go back home? Right, the bus stop is outside the bank. And the mother says, oh, I also forgot to bring my wallet. I tell you what, I'll take out $10 and I'll put it back tomorrow. Has she committed a misconduct? Would you sack her for taking that $10 because she's going to put it back? Who says here that he won't sack? But the qualification is, she said, I'll put it back tomorrow. And she eventually put it back the next day. Would you sack her for what she did? Giving her poor son 10 ringgit, brim, right, to go back home. It's not brim, it's bus ride. Satu Malaysia to balik rumah, right? Would you sack her? Assuming she put the money back. Let's move one step further. Assuming she put the money back, she was caught after the event. Would you sack her? Yes, who said no? Who says no? I think she deserves to be sacked, because you have to look at the nature of the person's... First, you have to look at the nature of your business, and secondly, the nature of the employee's employment, right? She is a custodian of public funds. She's a cashier. She's entrusted. It's like you hire a security guard. I had a client of mine. He was MD of a big company. One day he decides to drive to the plant. Security guard, supervisor, all fast asleep in the same room. I said, sack all of them. Because you are paying that guy while you are asleep for him to stay awake, correct? If not, you might as well also go there and look after your factory. So you have to look at the nature of the employment and the position held, right? It is immaterial whether you take $1 out or $1 million out or $2.6 billion. It doesn't make any difference, right? As long as money leaves, that's it. So what you need to do, now I'll give you the third scenario. The third scenario is the same Bangladeshi worker who had that one bun. You said you won't sack him, right? Because he had one bun. You give him what would you do? Would you give him a warning? Would you give him a demotion? I'll come to that. How do you manage minor, major? Assuming you give him a warning saying don't repeat. But what if this Bangladeshi worker, every 10 buns which come out, he takes one bun and he opens a bakery down the road calling it Bangla Bun? Would you sack him? Absolutely, right? So, at the end of the day, it's how you manage a situation like this. You must be able to ascertain, and again, I feel sorry for HR practitioners. I hope there are bosses here who will appreciate HR practitioners, because if they are pro-union or pro-employee, the bosses says you're not acting in the best interest of the company, this, that, the other. If they are against the employee, they get a hard time from, I've got HR managers who have got stripes in their car, corporal, sergeant, 3 lines, 2 lines on their beautiful cars, not knowing who are the culprits, right? So, what is important is, at the end of the day, the nature of the misconduct and how the company operates. Okay? Now, I had another case where what punishment to impose? If you look at the Employment Act, it's also in my paper, it says you can demote, downgrade, or impose any other lesser punishment. But the Employment Act, you must remember, is for people who earn below 2,000 ringgit. Okay? So people outside the scope of the Employment Act, there is a trend to say that, okay, a similar kind of thing, because the courts say dismissal is the last resort, correct? But if you stick on those three scenarios I gave you about the one bun, the 1 ringgit, and the Bangla bun situation, you can't go wrong. You can't go wrong, because that is just bear that in mind, it's easy. You'll be able to take that through. But if I've had a case where after inquiry, so the management said, too harsh to dismiss. They decided, don't dismiss. So they said, let's demote him. Now, if you demote, what position do you demote to? How far can the demotion be? So in that case, they demoted the guy, I think it's SPK and Johari, I put that there. They demoted the guy, but he claimed constructive dismissal because he says, you demoted me. And you know, constructive dismissal, if there is a unilateral variance to the terms and conditions of employment, that will entitle the employee to leave. But our argument was, it's a punishment. I could have sacked him. The court says dismissal should be the last resort. So we didn't sack him. We demoted him. Now, it's like a pilot, right? You demote him to co-pilot and you give him the captain's salary. Do you think he'll be happy or sad? Because nobody knows what happens. He walks in with his briefcase, he looks smart. All the people say, wow, my captain, damn good looking fella. Walks in, he closes the door, right? You can't even enter now, to say hi. Which side he sits, who cares? Captain on the left, co-pilot on the right. But he doesn't care. Some of them don't even wear the stripes until they get in the plane. So I would rather be a co-pilot earning a captain's salary, don't you think? Because the responsibilities, it's like a partner. I say, okay, Tava, you have committed a misconduct. I'm demoting you to a senior associate. But your salary will remain the same as a partner. You think I don't want that? Because I won't be sued. I don't have to worry about the accounts, right? I'd rather be a glorified LA. So, what do you do with a situation like that? Surely you must reduce his salary also, because otherwise you're not imposing a punishment. Some people misunderstand. They say when you demote, right, that is good enough. So from manager he becomes assistant manager, that is a demotion. But my view is, and I put that in my book and I've quoted, because in the case of SPK and Johari, what happened was the court relied on a decision, a chapter in a book by Selwyn, right? Hang on, just come to that. This is the Carlsberg case. Okay, in this case, in SPK and in Johari, they said, this is what the judge, I think Daman, it was Rajasegran, I think, Rajasegran, he was a former HR manager in Tyco Plantations, I think, right? He was from Tyco. And then, now he said this, that demotion has serious consequences upon a workman, cannot be denied. And more serious is a demotion with a reduction in salary in the instant case. The claimant's salary was reduced by about 28%, from 7,000 to 5,000. There was a drastic change to his earning capacity through his contract of employment, upon which his livelihood depended. And to a right of livelihood the claimant is entitled to, if not directly by Article 5.1 of the Federal Constitution, definitely by way of authority of Gopal Sriram speaking in the Hong Leong equipment case. Right? Now, the court therefore holds that the company, having no right to exercise demotion as a punishment upon the claimant, had not merely breached a term of the claimant's contract of employment, but had essentially offered him a new revised contract of employment which he had no choice to accept or reject. Then the judge quotes this English publication, Selwyn's Law of Employment, the 7th edition. If there is an express power to do so in the contract or rules, then provided the sanction has been fairly exercised, there should not be any legal problem. In the absence of such power, it could be a breach of contract by the employer and hence amount to constructive dismissal. This was what was stated in the 7th edition which the judge referred to. But in a later edition, right, in Selwyn's 12th and 14th edition, the English author made a significant departure when he said as follows, right? If there is an express power to do so in the contract or rules, then provided the sanction has been fairly exercised, there should not be any legal problem. In the absence of such a power, a demotion imposed following a disciplinary hearing is not a breach of contract when it is lesser penalty than dismissal which could otherwise have been imposed. So now the question is, how much? A lot of people come and ask me, so how much do I deduct? So my starting point is, if he was in a grade, what is the highest grade in the grade below? So say if he was a manager and his salary is 10,000, if you're moving him to assistant manager, the highest grade which he was before he became a manager. So if it's about, because some assistant managers also, their grades may be lower, but their salary scale can even go up to $12,000. So I said, look back at what he was in his previous position, right? But it has to be reasonable. To me, I think a 20, Dam, you would agree with me, 20% is a reasonable deduction. Right? I think here the court said 28 is too harsh, but it relied on an English decision. But in my view, I think 20% is a reasonable amount, because there must be some kind of punishment. Otherwise, people say no problem. So in my MAS case, the pilots, this case also went all the way to the federal court. 3 pilots were demoted after disciplinary proceedings because they were involved in setting up of another airline, and there was conflict of interest allegations. So what happened was the company demoted them. There was a number of appeals. So eventually they were demoted. First supposed to be co-pilot, then eventually they were demoted to a lower down to 737. I think they were put back to 747, but as co-pilots. They walked out on constructive dismissal, right? And the court said they have no case. There was no breach. But we had to establish the misconduct. So you must remember, when you demote someone, it is not just to show that you can demote. You will have to establish the allegation first. So if you're saying that he acted in conflict of interest, then you must be able to establish that there was conflict of interest, and then you could have imposed a more severe punishment of dismissal, but recognizing that all-important right to a livelihood, you gave him a lesser punishment. So again, a lot of companies are faced with this. How do you manage? Because sometimes you have double standards. What is conflict of interest? Some people don't put it. It's not in express terms. I don't have to put it in your contract of employment, but it's an implied term that you are not supposed to act in conflict of interest. So if a guy sells kway teow at night, but he's a lawyer, would you do him for conflict of interest if he helps his father's business? No, right? But if he sells kway teow till 2 o'clock in the morning and comes to the office and falls asleep or doesn't go to court, what would you do? You'll sack him for coming to work late or sleeping on the job. But there is no conflict of interest. So as an employer also, you must be able to... I had a case, just to share with you, I had a company, now pornography, right? I had a complaint. A client came from overseas and they said, we will meet at the Mandarin Oriental. So I thought, okay. And we will not meet in the presence of the local people. So again, I thought they were going to do a reorganization or VSS or closure or whatever. The first thing the guy showed me was some pornographic material. So I thought, oh, this guy, something is wrong with him. Then he said, this is a complaint from our vendor, because somebody had sent, we have this habit of forwarding emails, jokes. So somebody had sent some pornographic material to the company. This guy just forwarded it to his friend. And eventually it landed up on one of the vendors. But the paper trail is there. The originator to where this guy got was from that company. So the guy lodged a complaint. So they told me, we got to take action against this senior manager for doing it. I said, no problems. We will suspend him pending a show cause. Let him reply. In the meantime, I said, you need to collate the evidence, right? This is one. Go into the emails, get your IT people to do it. When the IT manager came and met me, he was shivering. Literally shivering, I'm not joking. I saw, maybe he didn't like my face, I don't know, but he looked nervous, right? When I told him what he was supposed to do. And you know what we found out? From the top to the bottom, everybody has been sending this email left, right, and center. One fellow sent, this guy sent to CFO sent to CEO sent to his wife. So I told them, I said, because they said, oh, we are very strict, it's in our intranet, it's a dismissible offense, we are a big multinational, we can't condone such. I said, very good. Then you close down in Malaysia, sack everybody. Because you can't sack one guy, because disparity of punishment. This is the issue which Anand actually brought in in that CIMB case. Because what happened was, at the outset, when they issued show cause letters, some of them wrote in saying, I'm very sorry, I won't do it. Please accept my apologies, I made a mistake. So the company decided to impose a lesser punishment. A lesser punishment in the form of no increment, no bonus, those kind of things, right? So their argument is, it cannot be so serious. If you're saying illegal strike is so serious, why these guys also participated, but you did not sack them? Now, how do you react to a situation like that? Because we're all human beings, peri kemanusiaan, they say. So when a guy sends a letter and says, I'm so sorry, I didn't know that it was wrong. So the company said, misconduct, established, but you admitted guilt, you showed remorse. So I give you a lesser punishment. But the rest, they denied. So our argument in the federal court and the court of appeal was, what do? It's like when you plead guilty, you get a lesser, even some of the penal code charges, you say, I plead guilty. So they said, okay, 2 rotan, as opposed to 10, right? So similarly, because their argument is, oh, you say it's such a serious misconduct, why they got off? But it would be different if the guy puts his hand in the till and takes $10 and he says, I plead guilty, I'm so sorry. Would you give him a lesser punishment? No, right? You will dismiss because it doesn't matter. Even if he says sorry, that sorry is not going to hold any water. You're not going to accept it. So you have to actually study the nature of the misconduct, the impact. You see, even if you look at the Industrial Relations Act, when you talk about collective bargaining, they say impact on the industry, on the nation. So here also, you have to make a decision on the impact it will have on the workforce. Because if you allow one person off, everybody will use that as a precedent. Right? So this is where you need to be careful on how you address the punishment. So my view is very simple. It's good to have major misconduct, minor misconduct, but you can always say and anything else which is in contrary to your terms and conditions of employment. Right? Because we have got cases where during working hours, right, they say the staff is not acting in the best interest of the company. They are using the emails and sending out emails to people and doing side business, right? But a lot of us are caught in our own web. I myself, my secretary will come and tell me, boss, this product is very good, multi-level marketing. You got pimples on your face. Why don't you try this, right? So I myself go and buy from her to help her in her business, right? But we have got complaints saying some of them are using the phone, using the office email to do their business instead of working. I remember doing a case where the secretary, the company secretary, and I think one of the financial controllers of a company, during office hours, they were whacking the CEO by email, using abusive language, right? So when the company, it actually came out by accident when one document leaked. So the company then went into the email and they wrote to these girls and said, listen, show cause why disciplinary action should not be taken against you. Right? So this is also very important. How do you manage a misconduct? Always collate evidence and do not condemn a person unheard. Issue a show cause. Some companies, I always say, you don't need to have a domestic inquiry, because if you look at even the Employment Act, which prescribes minimum terms and conditions of employment, it says after due inquiry. It doesn't say after a domestic inquiry. Then you've got cases like Dreamland Holdings and all these federal court decisions which say that the mere fact a domestic inquiry is not properly constituted is not fatal, because the proceedings before the industrial court is de novo. You present the case. You can't go to the industrial court and say this is a beautifully prepared DI. Mecca helped us to do it, so please endorse the findings. The court will say, listen, you call your witnesses, prove the case afresh, right? A DI is good, a show cause is good, but there are sometimes when the company says, I can't do a DI because he's the most senior guy in the company. Who do I call? And if you bring an outside party to come and do a DI, which I've had the experience once, the first question the lawyer on the other side asked him, are you an employee of the company? No. So what is your relationship with the company? Oh, I'm a consultant. So how much do they pay you to do this DI? So the moment you're paid to sit in a DI, right, they cast that. Of course, you would, I'm sure the guy was doing it in a proper and professional manner, but the question is, there is a doubt cast, right? So, very important that the documentation and paper trail is there. So, there was this case, I just want to just highlight to you this domestic inquiry. This case, of course, when an employee admits guilt, Petroleum National against Mohammad Razwan Ramli in my paper, there is nothing further to inquire. But you make sure he admits guilt in a proper manner, right? Sometimes you issue show cause, he replies saying, okay, I admit. I have got cases, again, how you manage. A client of mine said, I wanted to get rid of this person. They did the paper trail. Eventually, I asked them, how? He said, oh, the guy resigned. I said, oh, fantastic. I said, send me the letter of resignation. You know what was the opening sentence in his letter of resignation? I refer to our meeting, as per your request, I hereby tender my resignation. And they accepted it. So, that will be the next step when the guy uses it, the precursor to a case in the industrial court, because he said, I was forced out of employment. So you must immediately write back saying, no, I did not ask you to resign, You resign on your own volition. So, the other case which I highlighted is the Malaysia Airlines case, because a due inquiry is good because, hang on, just have a look at this case. Okay, in this case, it's interesting because, do you remember the old Subang Airport? So they had this what do you call this, cargo site, and these burung tiungs. You know what's burung tiung, right? These birds which could talk, but of course the birds didn't tell us who tried to steal it, right? These birds were supposed to be exported overseas, but the people who were involved in this export process, they found that not all the birds turned up. And the airlines confirmed none of them flew out of the plane as they took off. What happened was these guys were stealing these birds while they were at the premises. If you're familiar, there's a Chinese restaurants in Terminal 3, right? As you drive to Sungai Buloh. So that just the opposite was where these cargo sites were. So the guy who caught this guy stealing, right, recorded his statement. They recorded his statement. He gave evidence. The inquiry, the investigating officer recorded a statement from him. Then they went to the DI. The notes were taken down verbatim. Everybody had to sign. The prosecuting, each page, everybody signed to confirm the verbatim notes. It's very important because later on people say, I can't remember. I've got cases again. Management of this. The company took down verbatim notes. And then they typed it out. Susan, the secretary, types out the verbatim notes. 2 years later, I said, where's Susan? Migrated to Perth. Where's the original notes? I don't know where. She just typed out the handwritten notes. So how much weight can the court give to the DI notes? So what happened in this case is this poor gentleman, he passed away. Baldev Singh passed away before the case came up. The guy who caught him stealing. So of course my opponent, he was saying, I want to see Baldev Singh. I said, I'm not prepared to go 6 feet underground at the moment, but you can go if you want to see him, right? So, we had no witness. But this is what happened in this case, right? I just highlight to you. The court held, we relied on Section 73 of the Evidence Act, and the court held a due inquiry properly conducted and well documented serves to ensure that a disciplinary authority has acted only after giving fair consideration to the matter. It also provides a reliable record for the employer to turn to when, due to the deflection of time, witnesses have become unavailable or memories have faded. The employer is faced with difficulties in having to prove his case before an industrial tribunal. Confronted with such forensic difficulties, an employer might well have to make extensive references to records of the domestic inquiry. Right? The court agrees with the submission of the Learned Counsel on the admissibility of the documents. In particular, having perused the notes of the domestic inquiry, the court is satisfied that there was a fairly conducted inquiry in which the claimant had ample opportunity to cross-examine Baldev Singh, because the union was there. During the inquiry, they cross-examined him, they asked him what happened, so he's given his version of the story, all recorded. Having said that, it is necessary to state here that the court must, however, assess the evidence as to the creditworthiness and the weight of evidence of the late Baldev Singh contained in the document. So the court gave some weight to the evidence. You know, it's very important. I don't know how some of you all see, even when I go to do cases, a lot of people can't remember. You know, when we go and meet witnesses, one day I went for a particular meeting. When I asked the witness, he just looked at me blankly. I said, do you remember what happened? He said, boss, 3 years ago. So I said, I know, but 10 minutes later, the HR director and the CFO walked in. Suddenly, he must have been taking GNC tablets immediately after that. His memory came back. He could remember. When the boss walked in, they could remember. So this is where the danger arises, because I have cases where a guy comes to the DI. A DI is convened 3 weeks after the incident. When the question is posed to the witness, nampak tak kejadian? He says, tak berapa jelas lah sebab malam tu kabur, dia bergaduh tapi tak nampak jelas. Pukul berapa? Tak ingat lah, lebih kurang 7 ke 8, tak ingat. Right? But 3 years later, when he comes to court after taking his GNC tablets, he suddenly ingat, when the question asked, saya ingat apa yang berlaku. Jam 7 tepat, 7 malam. Pakai baju jingga. Dia hentak dia dari kanan dan kiri. So, you know what the lawyer on the other side does? He just picks up the DI notes and says, 3 weeks after the incident, you said tak ingat. Kabur. This, that. Now, you can remember everything. So, his credibility is lost. So sometimes, you know, there are pros and cons of having a DI, but I think what is most important is no person should be condemned unheard. Everybody should be given an opportunity to state their case. So on your part, collate the evidence. Don't care whether it's minor or major. A misconduct is a misconduct, because a minor misconduct can become a major misconduct, right? And the tabulation of minor misconducts at the end of the day, when you have to make a decision collectively, because past misconducts are not considered spent. I did a case, it was called Japanese Cooperative against, I think, Kamala Loshini, where the court said, you cannot, because the girl, she had all, there were issues there, and then 10 years, nothing. Then again. So the court said, listen, past records cannot be considered spent unless you have something in your own policy which shoots yourself in the foot, where you say, after 3 years, it is wiped off the system, right? Then you can't rely on that kind of evidence. But if you don't have such a policy in place, then past misconduct, past records are relevant. Of course, the next question is, would it be the same? Because if the guy comes into work late, you give him warning, and then you give him warning for insubordination, there are two different types of misconduct. So his lawyer will argue, well, it's not the same. He was warned for tardiness, for example. But here, you're saying He's insubordinate. He's not complying with your lawful orders, right? So here you have to again make that assessment how you manage. Okay, so are you clear on managing minor and major misconduct? At the end of the day, I think the most important, as I said, is to manage your bosses, to tell them, listen, give you the resources, give you the money, give you the resources to be able to effectively manage from a HR and IR perspective. Because I think education is key. A lot of people don't know what is sexual harassment. A lot of people joke. I myself, if it was 15 years ago, I probably won't be standing here. You know? Because you joke. A lot of people joke with friends, they send out jokes. But the question is, if they don't know, they can't plead ignorance either. And if the end result is how the victim perceives your conduct, not how you perceive, what you perceive the act is. It's how the victim perceives the communication, right? And then what a reasonable person, the test would be, would you say something to a loved one of that nature? Would you send a similar, that ILU, would you send it to your wife or your daughter, right? Of course, some will say, yeah, I love my wife, I send my wife ILU every day, you see? But not in the context of here. And I did ask the claimant, I said, would you like if somebody else send that to your loved one? He said, tak boleh. But kerja boleh, So, do you have any questions? Have I passed my time? So, I've got 10 minutes. Any questions? Yes, please. Yeah.
Hi, Dr. Tava. Shahira Alba from MMHE. Yeah. I have a question. In a situation where employees have been arrested, and arrested as in arrested by the police, and then a few days later they were released on police bail. So the moment that the company knew about the arrest, the company put them on suspension, okay?
Yeah.
So when is it the right time for HR to actually initiate a disciplinary action? Because obviously we can't wait until the disposal of the case, in the criminal court, because it will, be a protracted litigation process. So when is the right time then for the company to institute? Thank you.
Yeah, I think what is important is the moment you receive such information, then it's triggered already, where you need to check with the police what is the nature of the misconduct, or why was he arrested, or why was he or she arrested. And then upon him returning, because you've already suspended him, now your suspension, is it pending investigations or pending the outcome of the police investigations? I totally agree with you. The police investigations may take time, right? Because if you can see now, a lot of issues which are there in the public now, they're taking a long time to investigate, right? So what you need is your own internal mechanism. But the question that arises is, if it's something outside the scope of his work, say assuming he participates in some unlawful demonstration. Some companies have that you are not supposed to, they say that you have put the company in an embarrassing position, or you have, what is the word, sorry? You have tarnished the image of the company, right? You've tarnished the image of the company. Now the question is, he's innocent until proven guilty, am I correct? So even then, what are you going to do? I have a case where the guy was involved in a theft. He was charged and released on bail. So he came back to work. Then my client said, I can't have a guy who's been, the theft was outside, with a group of people. They said, I can't have a guy. I said, fine. But where do you get the evidence from to establish the misconduct? Where do you get the evidence to establish the misconduct? Because this is outside the scope of his employment. It happened, say, in Port Klang, for example. Now, all the evidence would have been taken in by the police. Right? So, but I think the test is what a reasonable employer would do. If you have enough evidence, sometimes it's internal, right? You have an internal, say, for example, a molest case internally. He's also charged in a court of law. But for this kind of offences, until the case is completely disposed of, he doesn't get, there are no penal consequences, he doesn't go to jail. If he goes to jail, very easy, because you can go on the basis the contract is frustrated, because he is not turned up for work. But if he doesn't go to jail, some companies have got a provision there, but I'm moving one step further, where there is already an outcome by the courts. If you are found, if you're convicted in a court of law, right, then that will amount to a gross misconduct, which entitles you to be dismissed. Some companies have, if you are an undischarged bankrupt, if you're convicted in any court of law locally or in a foreign land, like MAS has that, because some of their cabin crew, if they're convicted in London or in Dubai, that will also hold water in Malaysia, in the sense that the employment contract is terminated. But to answer your question, where the police have released him on bail, it's an offence outside the scope of his employment, he's still innocent until proven guilty, then actually it really depends very much on the facts. Because if you can get the necessary evidence, if people can come, otherwise the risk you take if you dismiss him is if he's acquitted by the police, by the courts later, or if the police, sometimes the police decide not to proceed, they drop the charge, then you are in a predicament. I think we have a case now where the employee was caught for Kalwat, but the Kalwat case in court, the Sharia court has not been decided yet, but the proceedings in the industrial court has already commenced. So the question will arise is, what happens if the Sharia court doesn't find him or her guilty of an offence, but you have dismissed? But I had one case where the guy was dismissed, they had an internal inquiry, but at the same time they lodged a police report, and he was charged. But the company dismissed him on the evidence they had. You must remember, at the industrial court, the beban membukti is on a balance of probabilities, right? In the criminal courts, is beyond reasonable doubt. So what happened was, here we dismissed the employee, but by the time, so after he was dismissed, he went to the industrial court. By the time he was actually acquitted by the sessions court, the magistrate's court, for that criminal offence, but the court said, listen, these are two separate jurisdictions. As long as, based on the evidence, you acted reasonably and there's sufficient evidence on a balance of probability to establish the misconduct, then you're okay. But I still haven't answered your question. And I tell you, 26 years talking big as a lawyer, I really can't answer your question, because what do we do? Can we sack? We can't sack. Because, you see, a lot of people also can kena fitnah. Right? Agree? I mean, you are HR practitioners. You are the first on the target list to be fitnah. Yeah, there are all kind of people be writing letters about you. That's why I always say, never react. Surat layang, take and throw in the dustbin. The guy has got no guts to state the facts. But some surat layang you have to address, because if they say every night there's a theft, they're stealing things, and then you say, oh, this surat layang, go and have a look whether they're taking things out of the premises. But if it's something personal, right? No. I think I've spoken to many of you on the sexual harassment thing. I mean, people can come and make all kind of allegations. You are sitting down there doing an appraisal and appraising your staff. Next minute she runs out of the room screaming. What do you do? Yeah, you also run out together with them screaming. Because if you come out looking stunned, they'll say, celaka, he did something wrong. But you are genuinely stunned, right? Because I don't know why this lady is running out of my room screaming. But if you run out together screaming, then you will neutralize the effect of the thing, because you can say, we saw a ghost. You see? So always keep your doors open, right? And handle every case as it comes by. I can't answer your question. You know, it's very difficult. But that's the beauty of the legal profession. Let the court decide for you. Then you're not happy, you appeal. Not happy, appeal again. Then not happy, then you write a book and tell the story of how you lost the case all the way and how to avoid it, you know. Any questions? Yes, sir. I'm really sorry about that answer. I really feel bad, you know. But can you please sort out the next MECA seminar how we're going to sort this out?
Good evening, Dato.
Yeah.
Peng Ho from Financial Institution. I got a case here very peculiar.
Are you bound by BAFIA or something? Because you don't want to tell us which financial institution you are from. And is that your name?
Yes.
No, pulling your leg, sorry.
Yeah. This staff has taken annual leave. He went to Sogo. So he bought...
What's the nearest bank to Sogo? Sorry.
He was on leave.
Oh, okay.
And he bought a basket, trolley of about 300, cost 300. One item was not paid. So he was caught by the house detective, and he was actually taken to the Dang Wange. And during the police report, coincident that's dealing with Dang Wange with the special portfolio with the financial institution, and they call one of the manager and said that one of your staff has been caught shoplifting. And this was reported to HR. HR gave a show cause letter. And then the staff replied the show cause letter and saying that the charge was basically you tarnish the bank image. But my question is, she's on leave. Irene is on leave, she's on leave. My question is, if an employee is on leave, weekends or public holiday, this individual goes to the Sogo. When he walks in, did he tell that I'm from this bank? So how is that this employee tarnish the image when he's on leave, public holiday, or during weekends when he's caught shoplifting? Finally, this case was not taken up by the police, but the bank has terminated the lady. My question is, if he's on leave, public holiday, or weekends, did you represent your bank when you go to a shopping mall? Thank you.
Okay. Did she wear a shirt with the bank's logo on it? No, I'm just joking. No, at the end of the day, what you need to look at, to me, I think you cannot draw the line. Tarnishing the image can also imply, it doesn't mean that you have been convicted. The fact that you have been brought to the police, because tarnishing the image is a very fine line. How do you tarnish? The fact that the police call the bank, he's subject to all these things, also is tarnishing the image of the bank. You agree with me? When he's picked up, he may say that nobody knows I'm from whatever bank, but it's still a question of being picked up. The end result was not found. I mean, he or she was not convicted, right? There was no charge. No charge. My view is, it does not mean that if you are working, that you have got these pockets in the course of the week or in the course of the month to give you some form of immunity. The whole purpose is that even when you present yourself outside, you must present yourself in a way that befits your nature of employment. The question that arises is, I don't think you will have a hard case to prove if the person was not charged or found guilty. I don't think you will have a case. Because, again, a person is innocent until proven guilty. Sometimes mistaken identity, right? Sometimes somebody could have put the thing in the bag, so the police decides not to charge. So, where you are in your case, on the facts, right, on the peculiar facts of your case, I don't think you will have a case to sustain in the court. I don't think it'll be tough. if she was convicted, then you would have definitely grounds to argue that you've tarnished the good name or good reputation of the bank. But not, I mean, some people have this private, they have problems with their spouses, right? Would you sack someone if there was a Kalwat raid and the person is caught? Would you say tarnish image? Or would you wait until until the person is convicted? So I don't know. I mean, my view is you cannot condone it. So sometimes some companies say, listen, you are on paid leave until the resolution of this matter. But the question is, how long do they go on paid leave? If the case takes 2 years, also unfair on the other employees. Why should somebody be paid to go on leave? What are your views? Tarnish, you have to be... Because again, at the end of the day, if it's an internal thing, if she had been caught stealing within the bank, and the police decides, some companies, they launch a police report. The police decide not to charge. But you have got your own evidence internally to do that. I have one case where the staff stole somebody else's handphone. It's on CCTV. And the complainant decided, the person who lost the handphone decided not to pursue. When they initially lodged a police report, when they took the CCTV recordings, the person said, okay, I got back my phone, I don't want to pursue this matter. I don't want to destroy somebody else's livelihood. But my client, and so the police report was withdrawn. No police charge. But my client still proceeded to dismiss. Because you have evidence internally. In your case, do you think the supermarket is going to give you CCTV recordings of this person taking or shoplifting? Definitely not. So I think, do you agree? I think they'll be hard pressed, right? They're hard pressed. A tough case. Any other questions? One last question. Sexual harassment, my favorite topic. Anybody? Okay, none. Thank you very much. Thank you.